As the Vice Dean for Studies of our faculty, I would like to welcome Professor Teresa Ruso from the University of Salerno Law Department and the distinguished lecturer on the various issues of international law, cybersecurity, EU migration law, etc. And I would like to give her a word because she is going to give us a lecture on the issue of critical issues in the relationship between the rule of law and the EU enlargement policy. Professor Ruso, the floor is yours.
Thank you very much. Sorry, I would like to close this, but I know. Okay, thank you very much. I would like, first of all, to thank Professor Costi to strongly want this lecture of mine, as well as the Vice Dean, Professor Vucetic. I hope I pronounce well your surname.
Yes. Excellent.
And other authorities of the University of Nice. I warmly thank you because you gave me the opportunity to introduce and open the activities of my chair program, my chair, Jean Monnet Chair, promoting public awareness on enlargement policy, EU values, and the Western Balkan accession. The chair is set to focus on the evolution of EU enlargement policy and its implication in the construction of EU identity, based on its core values, according to Article 2 of the Treaty on European Union, as well as on the EU strategy towards the Western Balkans. Therefore, the chair Servant aims at building up awareness, expertise, and competencies in those who will attend its courses, skills that are critical in the current stage of EU integration process for the construction of a wide community of law based on the respect for democracy and human rights in particular. The more than 100 hours of our activity, yearly activities, will include lectures, seminars, training, included in a live format. This will be held in Italian for Italian students, but part of them will be addressed to graduates, PhD candidates, and as well as all stakeholders, and will be held in English, also by professors of Western Balkan countries. The activities of the chair will consist of a main course concerning enlargement policy, EU values, and the Western Balkan accession that will be held by me, and a law clinic concerning EU cooperation on justice and home affairs with the Western Balkans that will involve the participation of legal experts and academics. Each year, the chair will be concluded with the two international conferences, one in Italy and the other in a Western Balkan country, concerning the promotion of a public awareness on EU enlargement, EU border enlargement, Western Balkan accession, respect for EU value, but also include the topic of the fight against transnational crime and the rule of police and judicial cooperation. And that said, the topics I will cover in the chair are indeed many, but one of the topics that is certainly central and is precisely the relationship between the EU values, in particular the rule of law, and the enlargement of the Union. Above all, because the respect of this principle became central in the EU enlargement process towards the Western Balkans. I will do so by dividing my presentation into two parts. I would like to share with you my presentation. Okay, let me know if you see the presentation. Okay, do you see the presentation?
Yes.
And according to so I divide the presentation into two parts. One relating, these are the main points of my presentation, but this presentation consists of two parts, one concerning some general consideration on the notion of the rule of law, the emergence of this principle also on international and European scene, and above all, the formalization of this principle in the EU system, then the enlargement policy and the role that this principle achieved in the EU enlargement policy. Moving from the first point, that is some general consideration on the notion of the rule of law, we can say that this is a real controversial and very complex notion, also from a terminological point of view, which reflects different theories and brings together different concepts. It has been considered as the most elusive legal concept. This notion, in fact, is not only indeterminate and controversial, but has also an expansive force that contributes to the complexity, but also to the confusion of the speeches and debates that deal with it. The origin of this principle can be traced back to the 5th century before Christ with Aristotle, but it found its first theorist in philosophers such as Montesquieu, Locke, Rousseau, and Kant. From a historiographical point of view, it refers to the experience of the liberal political regime that were established in Germany, France, and Italy between the end of the 19th century and the first 2 decades of the 20th century, and in parallel to the experience of the rule of law of the Victorian age. So we can say that it can be distinguished two main concepts: a continental notion of the rule of law, Stato di diritto, Rex, Stats, État de droit, and in this case, the law is an expression of a popular sovereignty, and from this it draws legitimacy and strange. Individual rights depend by parliament, holder of the normative power, and the judge is extraneous to the democratic process and is required only to apply the law. This conception translates in stricto sensu the principle of legality. On the contrary, in the Anglo-Saxon experience, the rules that govern social life are rarely the product of a voluntary imposition because the practice generates them. A judge-made law, and this law is useful in resolving disputes. The law must also be fair, impartial, and right. So we can say that these conceptions are really different, but they have in common the action to limit the arbitrary exercise of political power. Consequently, we can distinguish two concepts of the rule of law, formal and material or substantial. According to the first conception, everyone, including the state itself, is subject to law. Legal rules, whether their content, must be effectively respected by all. It does not intervene in the event that political power is exercised unjustly in violation of fundamental rights. According to the second conception, the rule of law cannot ignore the content of law. Legal norm must therefore respect certain imperative of justice. Therefore, we can say that the rule of law was born as a model of cooperation, as a model of relations between rulers and governed within the national political states, and was intended in a formal, a substantial or material sense. But it emerges also on the international scene and European scheme. And this was due to the several documents, such as the Universal Declaration of Human Rights, the European Convention, as you can read, for the protection of human rights and fundamental freedom, but also in the statute of some international organization, for example, the statute of the Council of Europe. And it was intended as a guiding principle for international relationships, as a basic principle for the functioning of organizations that member states of this organization are called to respect, and above all, in the European region, it was intended behind the strict principle of legality and also affect the protection of fundamental rights. If we look at, for example, some document adopted within the United Nations system, for example, the report of the United Nations Secretary General Kofi Annan of August 2004, we found that this concept is, principle is a concept at the very heart of the organization mission, because the rule of law was considered also as a goal that must be guaranteed for the respect of the international security among peoples. And it in fact consists to a principle of governance, but also it has must be consistent with international human rights norm and the standard. As described also in the annual report of the rule of law and human rights, it became also a sustainable development goal, goal 16, and in this report it is emphasized that the rule of law play a key role in promoting peaceful, just, and inclusive society, and in such way it guarantees also the sustainable development. If we look some other documents, for example, within the region, the European region, and in particular the report on the rule of law adopted by the European Commission for Democracy Through Law, the well-known Venice Commission, this report emphasized that there is a consensus regarding the constitutive elements of the rule of law, which include formal but also substantial or material elements. And these are, as you can read, legality, including a transparent, accountable, and democratic process for enacting law, legal certainty, prohibition of arbitrariness, access to justice before independent and impartial courts, including judicial review of administrative acts, respect for human rights, non-discrimination, and equality before the law. If we consider in the EU legal system, we can say that the affirmation of this principle in the EU legal system found a political, judicial, and formal perspective of affirmation. In fact, since the document, since the 1973, the then nine foreign minister adopted a document on the European identity and found that the principle of representative democracy, the rule of law, social justice, as well as the respect for human rights, constitute fundamental elements of European identity. Then the Court of Justice was really important because thanks to some decision of the court, and the first very famous party ecologist, Lesbertos, of 1986, the court stated that the European Economic Community is a community based on the rule of law, that is to say that neither its member state nor its institution can avoid a review of the question whether the measures adopted by them are in conformity with the basic constitutional charter, the treaty. But the formalization of this principle, that is to say the codification in the treaty, start with the Maastricht Treaty. It was firstly included in the preamble of the treaty, then in the Article J1, paragraph 2 of the Treaty on European Union, that is to say that rule of law became a goal of the common foreign and security policy. And then Article 130, paragraph 2 of the Treaty on European Union, that concern the development cooperation. So that is, it is important to say that the first, the position of the European Union was at the beginning to promote this principle in the external relation, in the external action. After, with the Treaty of Amsterdam, the European institution the European Institute designed to that there was the need of not fundamental values, but to give the Union funding principle. And so the Treaty of Amsterdam led to the introduction of Article 6 of the Treaty on European Union in paragraph 1 that state that the Union is founded on the principle of liberty, democracy, respect for human rights, and fundamental freedoms, and the rule of law, principles which are common to the member states. This principle must be guaranteed thanks to a sanctioning mechanism that was introduced always with the Treaty of Amsterdam, but in Article 7 of the Treaty on European Union. The Treaty of Nice that succeeded the Treaty of Amsterdam introduced also a preventive mechanism in the case of risk of violation of the principle of Article 6 and in particular the rule of law. And above all, Article 49 of the Treaty on European Union that concern accession of new members requires the respect of this principle included in Article 6. The Treaty of Lisbon, in a certain way, renamed this principle that became fundamental value, founding value of the European Union, and above all, this treaty underline or emphasize the multidimensional rule of rule of law because is a requirement for permanence as EU member. According to Article 7, it is necessary for the respect of EU, we can say, is a condition for membership, according to Article 49, as you can read, but above all, it became a value that must be exported in external action according to new Article 21 of the Treaty of European Union. So the new Article 2 that is in a certain way reproduce, but not exactly Article 6, says that Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities. These values are common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevails. But we can say that this article has been widely discussed, first of all, because of its wording that seems to create a different list of value, the first that are founding, the other that are common. Anyway, the EU institution has considered this article in a holistic way, as well as its value as a whole. That is to say, EU values. All these values are important, and are above all, these values are transversal in all the policy, in all policies of the European Union. But we have to say that the rule of law has been considered as preeminent, respect the other, but rule of law has been considered in conjunction or in connection with respect of human rights and democracy. In fact, this is clear starting from the enlargement policy, but not only. We have to say, that the risk, the threats that this principle, the rule of law, is living in the two last decade, has led the Court of Justice to adopt several judgments, several decisions. So we can say that this concept of the rule of law has been enriched by the findings of the Court of Justice, as well as by the opinions of the general advocates. These are a list, but is only some judgments of the Court of Justice that refers to the rule of law, because there are many other judgments and decisions that concern specific policies of the European Union, because we have to consider also, for example, the field of justice and home affairs, and in particular the migration, where there are many judgments of the Court of Justice. But with reference to the enlargement policies, that is the second part of my today presentation, first of all, we have to say that enlargement policy falls within the EU enlargement the EU enlargement, the EU external action. I thought it is formalized in Article 49, as we in connection with the Article 2, as I told before, on the Treaty of European Union. On the contrary, the external action, EU external action, is included in Part 5 of the Treaty on the Functioning of the European Union, and contains a series of articles concerning, for example, the commercial or trade policy, development cooperation, financial and technical cooperation with non-EU countries, humanitarian aid. But we have to say that this policy is a policy that put in connection internal, and that put in connection the inside and outside of the European Union. In fact, it is also closely connected with the neighborhood policy. In fact, mainly in the latest enlargement, the EU started to steer the domestic policies of states outside its borders and prevent the spillover of security issues from its neighborhood through various association agreements. And then decide the policy towards each different state that enter in relation, in connection with the European Union. We have to say that by pushing the borders outwards, enlargement determines the need to secure the new external borders and neighborhood of the European Union. On the other hand, the process of creating an ever closer union among the peoples of Europe and the need to preserve the acquis communautaire have transformed the accession of new member states into a EU strategy characterized by variable times and phases tailored to states that submit their application to join, and it following increasingly complex procedures. We can distinguish, for example, at least 6 stages: formal membership application, candidate status, pre-accession negotiation, ratification, and then integration. Thus, this policy has acquired some its own specific characteristic to the extent that EU enlargement implies geostrategic investment in the EU future as a new line of border defense, as the inclusion of new members in EU integration based on common fundamental values, with the aim of deepened solidarity between peoples, and as a transformation of the governmental apparatus of states involved via policy conditionality aim at ensuring the EU's internal and external democratic stability. So we can say that the enlargement policy has been considered as a driving transformation and modernization process in the candidate countries. This conception date back to the Eastern European country enlargement, and as became clearer with the specific reference to the Western Balkans, where the Union has combined foreign policy, intergovernmental mechanisms, and instruments aimed at stabilization and association, regional cooperation, and good neighbor relations. And these are can be considered the main features of the enlargement policy towards the Western Balkans. In particular, the area of freedom, security, and justice has acquired important weight in the Union enlargement policy for imposing justice and non-affair acquis on incoming members, thus underlining hierarchical conditionality related to the stability of institutions guaranteeing democracy, the rule of law, human rights, respect for and protection of minority for the next EU accession. So the Commission, with the Council endorsement, proposed a new approach to judicial reform and fundamental rights, as well as justice, freedom, and security as a part of the negotiation framework for the accession of the Western Balkans. The strengthening the rule of law and democratic governance became central to the enlargement process, and it was translated in the opening of chapter 23 and chapter 24 as a top priority in the negotiation. And this was evident since several documents, several communications adopted by the European Commission, for example, the first, the enlargement strategy and the main challenge of 2012-2013, the Commission underlined that to improve the negotiation, there was the need of a great emphasis on the rule of law issues. In the strategy of the 2015, the commissions emphasized that the backbone of the enlargement policy was the focus on the fundamentals linked to the core of EU values, and above all the rule of law. In particular, countries aspiring to join the Union would have needed to establish and promote from an early stage the proper functioning of the core institution necessary for securing the rule of law. In the 2018, there was a relaunch of the enlargement process towards the Western Balkans with a new strategy concerning a credible enlargement perspective. And in 2020, and in particular in the strategy of the 2020, the Commission introduced a revised methodology for enlargement to the Western Balkans. This confirms the crucial role of EU member states, calling for a stronger political steer at highest level and advancing political and policy dialogue through regular EU Western Balkan summits and intensified ministerial contact. In two latest communications of 2021 and 2022, the latest was adopted the last 12 October, we found that the Western Balkans are now closely associated with the work of EU agencies in the field of justice and home affairs. The Commission underlined that there was a structured cooperation with the EU law, but there is that a number of relevant recommendations related to the rule of law reforms remain and are a priority. In the latest communication, the Commission underlined another time that the enlargement policy towards Western Balkans continues to drive forward transformation and modernization in the partner country and bring them even closer to the European Union. As you can read, they consider Western Balkans are a part of the European family. And it's important that they advance in the path towards full EU membership thanks to embrace and defending democracy, rule of law, and fundamental rights, which are at the heart of EU values. We can say that EU membership or the accession of new members is a complex process of adapting national legal order to a regime governed by liberal democracy with robust checks and balance, an independent judiciary, independent media, and civil and political rights. So enlargement has been considered a form of Europeization, more easily accepted by the policymakers of post-communist countries due to economic, political, and social crises that accompanied the end of communism. But in these cases, with this country was adopted a pre-accession strategy that was put in place and was intended to guarantee a sort of roadmap in the implementation of EU-led reforms and above all in adapting the acquis communautaire, thus turning enlargement into a policy with a transformative aim. Nevertheless, as we say before, rule of law are strictly connected with the fundamental rights and democracy, and this is both in internal, external action of the European Union. So the rule of law is not considered in isolation, but always in connection with the fundamental rights and democratic governance. Its implication required, in fact, institutional transformation, ensuring independence, the quality and the efficiency of the judicial system, as well as a strong framework for the prevention of corruption and the full implementation in practice of fundamental rights, strengthening the functioning of democratic institutions and public administration reform. So we can say that this principle must be understood and promoted as interconnecting and interdependent principle. Nevertheless, the safeguard tools for its protection under primary law, that is to say Article 7 that I showed before to you, as well as infringement procedure and refers for a preliminary procedure, some of the list of the decision of the Court of Justice come from these procedures appear inadequate. Therefore, the systematic threat to the rule of law led the Commission to adopt the 2014 rule of law framework. Which for the first time introduced a mechanism for assessing whether a member state had endangered this principle sufficiently that Article 7 should be invoked. Nevertheless, this framework was not considered sufficient or useful to guarantee the respect of the rule of law in connection with fundamental rights and democratic governance. So the Commission proposed a new mechanism which underline the need to protect EU budget from financial risks linked to generalized deficiency regarding the rule of the law. That is to say, the Regulation 2019-2 of the European Parliament of the Council of 16 December 2020 on a general regime of conditionality for the protection of the Union budget. If we look at some recital of this regulation, for example, recital 3, recital 6, and recital 5, we found that rule of law required that all public power act within the constraints set out by law in accordance with the values of democracy and the respect for fundamental rights as stipulated in the Charter of Fundamental Rights of the European Union. It required, and then you find in this part all the elements that were already underlined by the Venice Commission. In the recital 6, this regulation highlights that since there is no hierarchy among EU values, there cannot be democracy and respect for fundamental rights without respect for rule of law, and vice versa. That is to say that there is a preeminence of the rule of law, because only if there are a system that guarantee rule of law, we can have democracy and respect for fundamental rights. But above all, we found a clear signal in the recital 5 towards new member states, particularly in the part where the regulation specify that once a candidate country becomes a member state, it joins a legal structures that is based on the fundamental premise that each member state shares with all the other member states and recognize that they share with it a set of common values on which the Union is founded, as stated in Article 2. That premise implies and justifies the existence of mutual trust between the member states, that thus value will be recognized, and therefore that the law of the Union that implements them will be respected. The laws and practice of a member state should continue to comply with the common values on which the Union is founded. And I think that it's really important that according to this regulation, and then also according to the interpretation of the Court of Justice, we found that membership between EU membership is a qualified membership, because it's a mutual membership based on a mutual trust, mutual trust on common values that are common to the member states. In fact, Hungary and Poland brought unsuccessfully action for annulment before the Court of Justice. These are the cases before the decision. The first is the decision of the Court of Justice. But the case was important, has been very important, because gave the court the opportunity to underline, recalling the aforementioned recital 4 or 5 of the resolution, that compliance by member states with the values contained in Article 2 is a condition for the enjoyment of all the rights deriving from the application of the treaty to the member states. But above all, that this compliance with those values cannot be reduced to an obligation with which a candidate state must meet in order to accede to the European Union, which it may disregard after its accession. Furthermore, the court emphasized the close connection between the rule of law, solidarity, and other values included in Article 2. In fact, it clarifies, the court clarified that the union budget is one of the principal instruments for giving practical effect in the European Union's policy and activity to the fundamental principle of solidarity between member states, and that the implementation of this principle through the union budget is based on the mutual trust of member states, based on the common values. And these require the responsible use of common resources included in the budget. So we can say that consequently, the problem of the rule of law backsliding post-EU accession has a result in strengthening the conditionality regime for acceding country, and above all, with reference to the economic instrument. In fact, as you can read in the regulation 2021/5029, that assistance could be suspended in the event of degradation of democracy, human rights, or the rule of law by a beneficiary, recital 14. In this direction, we can say that sound financial management seems to be the only instrument adopted to overcome the disconnection between the internal and external framework. And above all, that although the treaties include different mechanisms, as I told before, none of these have been specifically dedicated to protecting the rule of law and try to overcome the problem of backsliding post-EU accession. So, in conclusion, I have some consideration. First of all, the enlargement policy toward Eastern Europe, Eastern European country, has been applied to the accession of the Western Balkans, although with a strong focus on the principle of fundamental trust. Although the rule of law is considered part of Europe identity, the soft conditionality adopted with regard to the Central and Eastern country generate rather divergent outcomes in this country concerning the rule of law. This principle is in fact intended in different way, particularly with respect to the functioning of national judicial system, traditionally falling within the province of the state's competences. As a result, a novel rule of law conditionality has been imposed to new candidate countries without, however, being able to produce results deemed adequate in terms of EU's political criteria. The events of the last decade, which have seen as a protagonist member states, in particular Romania, Bulgaria, Poland, and Hungary, and democratic backsliding in the rule of law, led to arguing that they are in some way the result of the repercussion of the enlargement policy on the EU fundamentals implemented by the EU institutions themselves. The accession of the Western Balkans has been affected in certain way by previous enlargement, and that have brought to light the lack or ineffectiveness of internal instruments for the protection of the rule of law. The transformation was to be inspired by the respect for the political criteria, the so-called Copenhagen criteria, which conversely underline on contrary, their weakness In fact, we can say that the lack of application after accession has caused a discrepancy between EU accession condition and membership obligation. All these has led to a strong criticism towards the famous Copenhagen criteria that was renamed as Copenhagen dilemma. That is to say, the EU's inability to reshape the legal political development in member states, falling outside the material scope of EU law post-accession date. Furthermore, the transformation concerning the Western Balkans has underlined the focus on the respect for an all-encompassing concept of the rule of law in a list of endless benchmarks that could be included in the context of technical assistance without becoming conditions for membership. Enlargement cannot result in an endless process, otherwise running the risk of losing credibility. As pointed out, no methodology can resolve the lack of political will, ending up affecting the credibility as well as the stability of the European Union itself. Above all, after the application for accession of Ukraine, Moldova, and Georgia. We have also to recall that Bulgaria and Romania are still submitted to a cooperation and verification mechanism that sought to hold to account the judicial and corruption issues in two countries and monitor the progress after accession. And that these states continue to adopt a political position or legislative reforms that undermine the European integration process. So, at the end, in conclusion, I wanted to underline some main critical issues. The first is surely the Union institutional setup, in particular, the requirement for unanimity in the enlargement policy. But there is also a dispute between hold and member state, between a strict entering to respect of EU values, namely the principle of Euro law, and the necessity, the need for EU solidarity with the Western Balkans candidates and respecting their right to equal treatment with regard to prior EU candidates in the Central Eastern Europe. But above all, there is we can say that EU membership perspective has not led a formidable democratic institutional change of the Western Balkans, particularly with regard to the rule of law standards, because consisting mainly in the transfer of justice and home affairs key and crime control policy to respect the rule of law principle, the current enlargement process has ended up relegating such country to a partnership limbo, despite being considered them a geostrategic investment in a stable, strong, and united Europe based on common values, as repeated several times by the EU institution. We have also to say that enlargement policy that did not consider the most important dimension of the accession process, namely the involvement of future citizens of the Union. The lack of consultation and discussion around the previous enlargement underline the opacity of enlargement decision-making. Conversely, there is a greater need to involve citizens in member states and promote better governance in candidate states, where discontent is spreading among the population. As emphasized, as hypothesized, a deficit of transnational solidarity at level of citizens spring into skepticism toward further EU enlargement. So my chair wants to promote public awareness on EU enlargement, EU values, and Western Balkan Accession in order to guarantee the participation of students, academic, but all stakeholders from Western Balkan country, also from Western Balkan country. Therefore, I thank you very much for your attention, and I hope to see you, to meet you very soon in presence. Thank you.
Thank you, Professor Teresa, on your very interesting lecture. Do we have some questions from the participants?
Hello.
Hi, Mima, how are you?
Hello, Teresa. How are you? Well, I hope that Vice Dean Professor Vučetić would like to give me some minutes to say hello to you again.
Of course.
Thank you, Professor. I would like to express great thanks to Professor Teresa, who gave us so interesting lecture, and also I would like to thank to our vice deans and our dean who are our hosts today. And for our participants, I would like to add something more. Well, we have had a great opportunity to meet Professor Teresa Ruso in Štip at international conference at their Faculty of Law. It is in Northern Macedonia for our participants who don't know that. And I was there together with Professor Maja Nastic and Professor Angelija Tasić, and they are with us today. And also today with us is Professor Marko Dimitrijević, who runs the Jean Monnet project at our faculty. So I would like to thank to all of them and to our PhD candidates who took part in this lecture. Dear Teresa, from your affiliations, we can see that you are very interested in West Balkans issues, and we hope that together we can and should cooperate in order to achieve, if not all, but most goals for well-being of our citizens. So, Teresa, thank you again for your lecture and for your participation and for everything today. Thank you, Professor Vučetić, for giving me the floor.
Yeah, can I add that at this lecture are also present my students of the my course of international organization, so I thank them for their participation, as well as some PhD candidates, my PhD candidate, Dr. Emanuele Vannata, Stefano Busillo, as well as my students that present a degree thesis on migration policy, Elisabetta Lambiase. I want to add that our agreement concerning teaching cooperation is Erasmus teaching mobility is in force, so we can imagine to come to exchange for teaching aim. We can imagine also to extend this agreement with reference to students if they want. I am very happy to include them in my activities. And above all, I'm very glad to say hello to a colleague from Nice that I already knew during the Macedonia conference, during the conference, international conference in STIP, and I'm very happy to know Professor Dimitrievich. And what about your Jean Monnet activities? I am very interested to imagine a cooperation among my chair and your activity, if you want. So I leave the floor. Thank you.
Thank you.
Thank you, Professor Ruso. Marco?
I hope that you can hear me. I have some technical issue with the Zoom application, but I believe that it is okay right now. Professor Ruso, it is my great pleasure to meet you and to be here today and to hear something about the critical issue in the relationship between the rule of law and European enlargement policy. Actually, in accordance with the aim of Jean Monnet model for European monetary law, this issue which are referring to the rule of law is also very important in public monetary management in European Union, especially in resolving monetary disputes, which are actually a new kind of administrative disputes, where we can see that full implementation of active and passive procedural legitimacy of European Central Bank. And of course, we planned an international conference for the third last year of our Jean Monnet model for European monetary law. And it will be our great pleasure if you are interested to be our visiting lecture next year. And of course, there is a lot of space for some very fruitful cooperation between your chair and our Jean Monnet model for European monetary law, I believe.
Oh, thank you very much. It will be my pleasure. I want to add also that I have to organize the two international conference that I have said at the beginning, and one of these must be in one of the Western Balkan country, and probably we are looking for look at Belgrade. Because one professor of the team chair comes from Belgrade. So we can imagine something also in your university.
Of course.
So we can keep in touch by mail. I think we can keep in touch. We can write an email each other. So
of course. Our international conference shall be dedicated to the influence of European integration on implementation of monetary legislation in Western Balkan. So I believe that there is some huge degree of synthetic and dialectical connection between the topic of your chair and our future conference. So it will be my pleasure if we are able to cooperate and maybe to give some cohesive and very fruitful projects as the result of that cooperation. It will be my pleasure, of course.
Yes, sure. Also to me, also for me, and so it will. I think that let's cooperate. Let's start our cooperation. I am really glad about this.
Okay. Of course.
Thank you very much.
Thank you.
If we don't have any other questions, once again, I would like to thank all the participants, Professor Ruso, Professor Kostic, and I would like to just give a brief mention that we will probably publish these recordings of this online lecture on our webpage and on our YouTube channel. And of course, I hope that this is only the first lecture of Professor Ruso in the series of online and I hope offline lectures as well at our premises at the Law Faculty, University of Nice.
Thank you very much. I will wait for you in Salerno, in our campus. Okay. So I will wait for you.
Okay. Professor Kostic, do you want to give us a final word?
Well, I think that it's my really great pleasure that we can gather together also via Zoom or in live. But once again, thanks to Professor Teresa Ruso, and thanks to you, Professor Vucetic, for organizing all our meeting and future meetings. I hope, I really hope, and now I know it will be. Thank you.
Once again, thank all of you, and see you soon. Bye.
See you soon.
Thank you.
Bye.
Goodbye. Goodbye.
Bye,
And,
Teresa. Bye.
thank you very much. Goodbye.
Bye.
Goodbye.